This year, something kind of quiet but incredibly important is happening in our federal courtrooms. It's a story that's been cooking for over 30 years, and it all boils down to one massive question. How do we make sure that the science used in a trial is actually, well, science? Let's unpack this legal journey and see why it all matters so much right now.
I mean, it's a huge question, isn't it? Think about it. When an expert takes the stand, they can sound so convincing. But what if their big theories are based on, flawed methods or ideas that haven't been proven? How does a court, and more importantly, how does a jury full of regular people tell the difference between real, groundbreaking research and just convincing nonsense? That's the challenge we're going to dive into.
For a long, long time, the courtroom could feel like a bit of a wild west when it came to scientific testimony. A lot of the time, the focus was just on an expert's fancy credentials, not necessarily on how solid their actual science was. This created a real battle for truth, where a good story could sometimes beat out good data, and that could lead to some pretty devastating outcomes.
And that led to this fundamental shift in thinking. The old way was often to just let almost any expert testimony in and then basically tell the jury, hey, you guys figure out who to believe. But that's a massive, almost impossible task. So the modern approach created a new, powerful role for the judge, not just as a passive referee, but as an active gatekeeper.
This entire revolution in courtroom science, you can trace it all back to one single, monumental case. It's really the hero of our story, Daubert versus Merrill Dow Pharmaceuticals. This case didn't just settle one dispute, it ended up setting a new standard for a whole generation.
Now, this standard has been on quite a journey. The legal fight kicked off in the late 80s, and it all led to a critical Supreme Court decision in 1993 that just changed everything. But the story doesn't stop there. It actually culminates this year, in 2024, when this standard is finally officially being written into the rulebook.
So the heart of that 1993 decision was this. The Supreme Court basically said, look, these modern guidelines, the federal rules of evidence, they now officially trump the older, much looser standards that were used before. It was a total line in the sand moment. A new era for evidence had begun.
And this ruling did way more than just clarify a rule. It created a brand new job description for federal judges. They couldn't just sit back and watch the information flow anymore. Now they were actively tasked with guarding the gates of evidence, making sure that only reliable information could get through to the jury.
And this new responsibility got a name, the Daubert standard. It's essentially a two-part test for any expert testimony. First, is it relevant to the case? And second, and this is the big one, is it scientifically reliable?
Okay, but how can a judge who's an expert in law, not necessarily in, say, chemistry or engineering, decide what's reliable? Well, the court gave them a practical checklist. Can this theory be tested? Has it been through peer review? Is there a known error rate? And is it generally accepted in its scientific field? It's basically a quality control framework for science in the courtroom.
And this really gets to the heart of the whole thing. The standard acts like a filter. It's designed specifically to catch and remove junk science. Those theories that sound plausible but just fall apart under scrutiny before they ever get a chance to confuse a jury. This isn't just an academic exercise. It can be the difference between justice and a life-altering mistake. So, you might be wondering, if this has been the guiding principle since 1993, why are we talking about it now? Well, it's because we're watching the final step in its evolution. It's moving from being a court-made rule, a precedent, to becoming an official, written-down law.
That whole process has a specific legal name, codification. So for the last 30-plus years, judges have followed the Daubert standard because the Supreme Court said so. Codification means taking that idea and literally engraving it directly into the official federal rules that govern every single trial. It's making it permanent.
And this isn't some abstract thing happening down the road. This major update to the rulebook becomes effective on December 1st, 2024. It's happening this year, which makes this a pretty pivotal moment for our legal system.
The actual change involves tweaking several specific rules of procedure and evidence. Now, the details are pretty technical, but the goal is super simple: to officially weave the principles of the Daubert case into the very fabric of federal law. Okay, so what's the big deal? Why go through all the trouble to codify a rule that courts have pretty much been following for 3 decades? What's the real-world impact of this on justice?
Well, there are a few huge reasons. This gives everyone absolute clarity, and it promotes consistency, so the rules are the same in every federal courtroom. It also reinforces and strengthens the judge's gatekeeping duty, basically acting as a clear reminder that they must vet this evidence. And, at the end of the day, it just makes it that much harder for shaky science to win a case.
This quote really just nails the whole point of the 2024 change. The idea isn't to invent something new, but to double down on a vital safeguard for fairness. It's all about making sure that verdicts are based on facts and solid methods, not just on who hired the most persuasive speaker.
And this leaves us with a final, really important question. In a world with AI, with super complex genetic analysis, and scientific fields that are changing by the day, the evidence in our courtrooms is getting more powerful and more complicated than ever. So, does that make the judge's role as a scientific gatekeeper not just important, but absolutely essential to the future of justice? It's definitely something to think about.